Hi, I'm Jason Stone. Thank you for trusting us with your injury case. Since you have a deposition coming up, we want to make sure that you're comfortable, know what to expect, and are completely prepared. We'll be here every step of the way to make sure it goes smoothly. Over the next few minutes, I'll explain what you can expect to happen so that most of your questions can be answered. You may not be familiar with what a deposition is. It's a chance for the other side, the people we sued, to ask you questions. The people involved are you, your attorney, the lawyer from the other side, and a court reporter. The court reporter's job is to record everything that you, your lawyer, and the other lawyer say. Truly, everything gets written down into a transcript, and then everyone gets a copy of it. Your lawyer's job is to make sure the questions the other side's lawyer asks are appropriate and that you answer them accurately. The lawyer for the other side is going to be asking all the questions. The deposition may be in person, or it may be remote. Either way, we'll be there with you and we'll prepare you beforehand. We prepare for it because, honestly speaking, it's very important to your case. The impression that you make during that deposition is going to have a significant impact on whether they want to go to trial or whether they want this to settle. This is because they're sizing you up from the moment they meet you to see what kind of impression you'll make in front of a jury. They're judging you, and we need to be sure that that doesn't make you nervous. The more prepared someone is, the less nervous they are, and that's our goal. The first thing you need to do is dress professionally. Something you would wear to a job interview or church. Business, casual. That shows them that you're taking this seriously. The second thing you can do is avoid arguing with them. If there's something to argue about, we'll do it for you. The insurance lawyer wants to see if you're likable. It doesn't matter if your lawyer's likable, just that you are. So let us decide if there's something to argue about. Lastly, you must be honest and believable. There is nothing that can make a case go sideways more than someone lying or stretching the truth in a deposition. Remember, the truth will set you free. So what can you expect to be answering questions about? Typically, they start by asking you about your background, where you live, who you live with, where you went to school, your work history, some questions about your medical history, and then they get into asking about what happened in this case. Whatever they ask, you're required to answer. The key is to answer them straight, short, and honestly. I always say there are 5 good answers. Yes, no, I don't remember, and I don't understand the question. Obviously, you can't answer all of the questions that way, but the point is, only answer the question and don't volunteer more information than what's asked. I like to use my mom as an example. I ask her, "What do you want for dinner tonight?" And she'll go on and on, telling me that she had Chinese food last night, Indian food makes her stomach hurt. She may want Italian, but tomorrow she has plans to go get a burger. I don't want to hear the inner thoughts inside her head. I just want her to answer the question so we can get something to eat. It's important to point out that the deposition is not your day in court. The jury is not there, and neither is the judge. Most people want to tell their story, but this is not the day for that. If the case doesn't resolve fairly, you'll get your day in court, and there will be a judge and a jury, and there will be an opportunity for you to tell your story. But please understand, the day of your deposition is an opportunity for the other side to get you to commit to a version of events that you're bound to. They want to confuse you and get you to guess and make up answers. They want to try to trip you up. No matter how nice they appear, they're the enemy, and you cannot let them get you flustered. And if you find yourself starting to get flustered and confused, ask for a break. It's okay, and encouraged. At the same time, don't act like they're the bad guy. Be polite and professional. Don't let them think they've got you on the ropes. Stay cool. If you don't understand the question, say, "I don't understand the question." Remember, you don't want to be like my mom and volunteer more information than they ask for. If they don't ask it, you don't have to tell them, and that's good for us. If they ask where you were going when you got into the crash, tell them I was on my way to work. And don't add the extra, "I had to be there for a meeting." Or they will ask you, "Did you ever have pain in your shoulder before?" If the answer is yes, then just say yes. Don't add, "I injured it when I was 12. They'll ask. And if they don't, shame on them for not being thorough. But we don't need to do their job for them. If they don't ask the question, it doesn't mean that it's left out of your story. It just means they don't know that part of your story. And the less they know and the less informed they are, the less prepared they'll be at trial, and the less likely they'll be able to hurt your case. So here's the rule. Answer the question, short and to the point, and do not volunteer. It's that simple. Another rule, don't exaggerate. When they ask, "Are there things you can't do since the fall because of your injuries?" Don't tell them, for example, that you can't lift your arm over your head. Unless your arm was amputated, of course you can lift your arm over your head. So tell them what's accurate, that you can't lift your arm over your head without pain or without difficulty. Another thing, don't rate your current pain a 10 out of 10. Jurors equate 10 out of 10 pain with being in labor or having been shot. The jury can figure out if you're exaggerating, and they don't like someone who they perceive as whining. Jurors respect people that tough it out. Now, it doesn't mean that you say, "I'm fine," when asked about your pain or limitations, because if you were never injured, well, what are we doing here? It's all about how you present. Remember, I said earlier, it's matter of fact, not whining, never exaggerate. Friends and co-workers and family members that have given us witness statements can talk about how bad it is to the jury. Let them whine for you because you don't want to be a whiner. Another tip, leave yourself some wiggle room and don't make definitive statements. The other side is trying to get you to commit to all of your answers so they can use them against you later on. For example, they often will ask all of the ways that the injury has affected your life. Once you're finished listing all of the challenges you've experienced, they'll ask you, "Is there anything else?" Well, we're all human and we all forget things, especially in the stress of a deposition. Instead of answering no, that's everything, give yourself wiggle room by saying, "That's all I can think of right now." If you give a definitive answer, you're married to it. And if you add anything else to that answer when you're in trial, they'll try to make you look like a liar. It'll go like this. "You remember back when I took your deposition and I asked you every way that your back hurts? And I asked you specifically, is that all? And you didn't tell me any others, and you were under oath. And now you're telling me you can't lift more than 10 pounds? Even though you didn't mean to leave it out, you've just become a liar in the jury's eyes. So to prevent that, leave yourself some wiggle room. Part of not volunteering information is not talking too much. If you're answering any questions in more than 2 sentences, you're talking too much. Make them keep asking, "What happened next?" 2 sentences, that's it. You don't need to convince the defense attorney, the enemy, of anything. Don't. Their job is to make you look like a liar. That's their goal. It'll look like they're trying to be your best friend, but resist their charms and don't let your guard down. The simple truth is that you were injured because of their client's actions. Don't forget it. We're in the right here. Don't let them convince you that you need to convince them of anything. They ask the questions, you give short, accurate answers politely. Nothing more. Like I said before, the insurance lawyer is going to start by asking a lot of background questions over the course of 2 to 3 hours. The only questions they're not allowed to ask are questions that we call privileged. And if they ask those, your lawyer will instruct you not to respond. But 99% of the questions they ask you, if not 100, will be privileged questions, and they'll be questions that you need to answer honestly and truthfully. So remember not to get defensive. Don't ask questions like, "Why are you asking me that?" or "Why is that relevant?" Because unless your lawyer instructs you not to answer, it's a question that they're allowed to ask. We're almost done. On the day of your deposition, make sure that you don't bring anything with you unless your lawyer instructed you to do so. No lists, no diaries, no journals, no cell phone with pictures. Leave all that in the car. The defense lawyer is going to be asking you a lot of questions going back years and years of your life. If they ask you a question that you don't know or you don't remember, it's okay to say, "I don't know" or "I don't remember." But you want to be honest and you want to be credible in those answers. So if you can make a reasonable guess, you should do that. For example, if they ask how fast you were going at the moment of the crash, and you say, "I don't know," that doesn't sound very credible. Maybe you're not sure, but you know it was under 50 miles per hour. A reasonable guess to that question sounds more credible and more honest than simply, "I don't know." Now, if they do ask you a question that you simply cannot remember, or you just absolutely do not know, like the speed of the other vehicle in a car crash, well then you answer, "I don't know." And they're not allowed to continue to pry, and they have to move on. Lastly, this is very important. Never deny the truth. If you have previous injuries, admit them. If there are issues that are true, acknowledge them. The defense spends an incredible amount of time investigating you, your social media, your medical history, your employment, everything. It would be a horrible and potentially fatal mistake for you to fail to disclose any information thinking, "Oh well, they'll never find out." They will, and it'll ruin your case because you've just committed perjury. We can help you with any issue other than perjury. Remember, we'll be right there beside you the entire time. We'll protect your rights. However, if you provide a false answer to what seems like a dumb question, something like, "Have you ever received a speeding ticket?" that may well make an otherwise irrelevant question become extremely relevant to your credibility and seriously damage your case. The defense already knows the answers to most of the questions. They've done their research. Let them see you're honest. Again, it's a test to see if you're credible, believable, and tell the truth. All in all, be polite, honest, keep your answers short, don't volunteer information, take breaks when you need, and don't worry. We know the facts, the strengths and weaknesses of your case, and we believe in you. Don't do anything that makes them think a jury is going to side with them. Be the best version of you, and we'll take care of the rest.